I'm Roger Citron. I'm a professor at Toro Law Center. This is a Toro Law Review podcast, and our guest today is Professor Susan Morse. She's a professor at the University of Texas Law School, and we'll be talking about cases that are to be argued at the Supreme Court next month in November, and they involve the current administration, President Trump's tariffs. So, Susie, thank you so much for joining us.
Well, thank you so much for having me. It's a delight to be here to talk about the learning resources case, as it's now known at the Supreme Court, and it is the case about tariffs that will be argued on November the 5th.
And before we dive in to the case, please tell us a little bit about yourself.
Yeah, I'd be glad to. I'm proud to be a professor and also the Associate Dean for Academic Affairs. So the person who thinks about the curriculum at the University of Texas School of Law. I've been here for about 12 years. Previously spent time at two law schools in California. And I am a tax lawyer originally as a practice in terms of my where I practiced when I practiced at both Wilson Sonsini and Ropes and Gray. When I first started in my career as an academic, I taught tax and wrote about tax. And then over the last 10 years or so, I've had the opportunity to branch out. I now teach property. And as tax law has become more and more enmeshed, or some would say tax law has realized that it must be enmeshed in administrative law, that has become part of my toolbox too. So this is a project that brings some of those different elements together.
Yes, there was one of the ways this podcast came about, of course, is that you have co-written an article that's forthcoming, I believe, in the Washington University Law Review.
Yes.
And it's the case, your article, are exactly at the intersection of these two areas, tax and administrative law.
Mm-hmm.
To bring people into the case,
Mm-hmm.
I wanted to start with sort of, you know, big picture, the
Mm-hmm.
separation of powers pieces
Mm-hmm.
of the case.
Mm-hmm.
So, can you just tell us a little bit about what powers Congress has? And then we can carry that over. I know this is a compound question, but carry that over into what authority the president has, or what actions the president can take in the context of tariffs for the case.
Yes, just as you say, this is a case that involves an Article 1 versus Article 2 tension that is mediated by Article 3, the courts. And we can start with Article 1. It comes first, after all, so there's a nice order to that. And the substance of Article 1 that's relevant for this case is that Article 1 not only gives Congress the power to lay and collect all taxes, duties, imposts, and excises, which definitely includes tariffs, but it also empowers and requires the House to originate all bills for raising revenue. Um, and those two things together emphasize that the ability to raise revenue, to impose taxes, to figure out how to fund the federal government is plainly from the four corners of the Constitution an Article 1 power that Congress holds. And that sets up the way that every court so far has viewed not only this case, but for the most part, tariff cases in general, which is that courts are looking for an answer to the question of whether or not there has been a legal and effective transfer of authority to impose or adjust or increase or decrease tariffs or whatever from Congress to the president. The tariff case law, generally kind of starts with the starting point that the power begins in Congress, and if it's going to be held by the president, it needs to be moved from Congress to the president through some kind of statutory delegation.
Yes. And let's go back to Article 1 super fast, if I may,
Sure.
which of course is You mentioned the word tax, of course,
Hmm.
appears several times, I believe, in what you were saying in Article 1.
Hmm.
Can you just, this is sort of a definitional question.
Yeah.
What is a tariff? And is a tariff a tax, always a tax, something
Hmm.
else?
So a tax is sorry, excuse me, a tariff is a tax on imported goods. It could be assessed as a percentage of the value of the good, or it could be assessed as a certain dollar amount per unit of good imported. Both are possible. Um, there are lists and lists, very detailed lists of different kinds of goods that are imported into the US and what kind of rate applies. Sometimes these rates differ by the country of import, sometimes not, the country, from which the goods are coming. So I guess from that perspective, it's the country of export, but the country of origin. Um, and the way that the tariff system works is that um, the a tariff is assessed based on the value when the goods arrive in the United States. The importer remits the tax, um, and there are various rules which you can imagine are necessary to try to figure out exactly what category does something fall into and what is its country of origin. So rules like substantial transformation apply to try to determine whether or not a purported country of origin really is the country of origin for purposes of the tariff system. And the Bureau of Customs and Border Protection dates to Alexander Hamilton's days as the Treasury Secretary to 1789. It's now under the Department of Homeland Security, although it was formerly under the Treasury Department. And the tariff system is really a niche system of law. Even has a specialized avenue that challenges to tariffs must follow in general, which is that they go to the Court of International Trade, which is an Article 3 court, and then to the Federal Circuit. And so that's the kind of a little bit of a thumbnail sketch of the law and procedure that surrounds this area of tariff law.
Yes, I'm here in New York, and I believe the CIT sits here in New York.
It does,
And of
yeah.
course, the Federal Circuit is in Washington, D.C. Um, the and then it's cases, plural, that we're talking about in connection with the challenge to the Trump administration tariffs here. Can you, I guess, take us into the cases and talk about um, what legal challenges were made to the tariffs? And let me just sort of, as you noted, one case sort of came up from the CIT to the Federal Circuit. Another case that's been consolidated, I believe, was filed in the United States District Court in Washington, D.C.,
Mhm.
and that's now also before the Supreme Court. Having said that, I'll stop so you can help us understand the issues.
Sure. As you say, there two cases are consolidated in the Supreme Court case that will be heard on November 5th. One case is called VOS Selections, and it's the case that came up through the expected route for challenging tariffs, which is to say, it was decided by the Court of International Trade and then appealed to the Federal Circuit. Both of those courts held that the challenged tariffs were not authorized by the statute that the president pointed to, which is a statute called the International Emergency Economic Powers Act, or IEEPA. Um, Another route that one of the cases that's now consolidated took was to um, go through the district court and District of Columbia, and the plaintiffs there, Learning Resources, had the challenge of trying to explain to the district court why the district court had jurisdiction to hear their case, because there is a provision of the statute that gives exclusive jurisdiction over tariff cases to the Court of International Trade. And what the plaintiffs and Learning Resources said, with which the district court in DC accepted, was that if a tariff was invalid, it was inappropriate to consider it a tariff case, and therefore the jurisdictional restriction did not apply. So VOS selections and learning resources split on that jurisdictional point, with, not surprisingly, the Court of International Trade trying to kind of protect its jurisdiction in tariff cases. But I think that it is, for purposes of the Supreme Court's exercise, probably a good thing that the district court decisions analysis is also available for them, because it just gives the court more to work with, and more to consider as they try to decide this important case.
Yeah, and then with respect to the substantive issues,
Mhm.
um, and by that I mean the challenge that was made. You used a word that, of course, comes up all the time in administrative law type cases, which is, oh, authorization. That is, um, can the administration point to or refer to um, uh, statutory authorization to do what it did here? And as I understand it, right, it's the administration is 0 for 3. That is, in the three cases that we've just described and set up.
Yes, that's right. And I think that it's absolutely right to start with the question of whether the statute authorizes the tariffs. And one reason I think that is that that really is the way that the tariff case law goes, all the way back to an 1890s case, Field v. Clark, which was the first case to uphold some discretionary authority that the president had over tariffs. Um, the setup has been, has Congress authorized the tariff? And this has been a really central question. So on that kind of what I'll call the ordinary statutory interpretation question, what the courts have been working with is, first of all, the statutory language of IEEPA, which authorizes the president to exercise various powers in an emergency that he may declare. Um, and one of those powers that he may exercise in a declared emergency is to regulate importation. And so that's the statutory text that the court is working with. Um, and before getting to the way that the district court and also the federal circuit have concluded that regulate importation does not authorize the president's tariffs, I want to do two things. One is just to sort of state which of the tariffs are at issue here. And the second thing I want to do is to say something about the most difficult precedent that the plaintiffs have to overcome. So first, as to the challenge tariffs, they are the tariffs that were announced and uh, for the most part, imposed as a result of the April 2nd announcement that the president made. These are the so-called Liberation Day tariffs, in other words. And they have kind of two components. One component is a 10% baseline tariff on all goods that come into the United States. This is in effect now, and it applies to almost all imports. There are two important exceptions. One is that it doesn't apply to imports from Mexico and Canada because of a pre-existing treaty. And the second exception is that there have been small carve-outs negotiated with both the European Union and Japan. But still, for the most part, it's a 10% baseline tariff. Then the other component of the Liberation Day tariffs was country-specific tariffs that were based on the trade balance between the U.S. and particular countries. And those two, for the most part, they were postponed. They may have been adjusted, but for the most part, they have been um, put into effect. Um, so that's the scene. Like those are the challenge tariffs. Those are the April 2nd tariffs that were said to be authorized by IEEPA. And then I might say something about the most difficult precedent, if is that an okay thing to do next? Okay. Um, the most difficult precedent is a case called Yoshida 2. It's a 1975 decision of the Court of Customs and Patent Appeals, which is the predecessor to the Federal Circuit as the appellate court for tariff cases. And in that case, President Nixon had imposed a, yes, 10% baseline tariff on all goods coming into the US for a period of about 4 months in the mid 70s. And the reason he did that had to do with the Bretton Woods Agreement and his goal of moving other countries off their currency pegs so that the balance of trade could flow more naturally and the US would not be in what he viewed as a weak position with respect to its exports. Um, and that was upheld by that appellate court, the CCPA. And it was upheld based on pretty much identical statutory language from an earlier statute called the Trading with the Enemy Act. That was like the 1917 version of 1977's IEEPA statute. That's a challenging precedent. In all the decisions so far, 0 and 3, as you say, the plaintiffs have been able to overcome that precedent, but it's a really it's a challenging question as to what's going to happen at the Supreme Court, I think.
Okay. And I feel like you've walked us around in the most helpful way possible. I think what you called sort of the statutory construction or ordinary statutory construction aspect or issue
Yep.
in the cases that will certainly be part of the argument on November 5th. There's another way to I don't know. I guess we could say, do you skin an apple?
Right.
That is another way to approach the issue, and that is the major questions doctrine, which
Yeah.
I believe is in the federal circuit
It is,
decision.
although as a
But
secondary, kind of as a
go ahead. Yes.
secondary point. Uh, uh, I think many people, including justices on the court, consider the major questions doctrine as just part of statutory construction. So that's partly why I use this idea of ordinary statutory interpretation with my co-authors, Shu Yi Wei and Diane Ring, who've written the paper together. So one reason I do that is to is in this presentation do that is to emphasize that I'm not trying to say that the MQD is not a statutory construction idea. I think in order to get to the MQD, I might have to say something about ordinary statutory interpretation. Would that be okay if I do that now?
Yes, that would be very helpful because I think that there's this sort of continuum. These arguments all sort of are related, yet they all are different. And I think this will help us sort of both sort of fit or understand the relationship between, I think, what you're calling, what I understand you to be saying with ordinary statutory interpretation, and if we're going to distinguish that from the major question doctrine analysis. So yes, please.
Yeah, I think that's right. Um, the ordinary statutory interpretation approaches that have been evident so far in the decisions that we have in both VOS selections and in learning resources have followed a couple of different avenues. For example, the Federal Circuit's decision analyzed the meaning of the word regulate importation and said, we think that the plain meaning of regulate does not include taxation. They distinguished the idea of regulation under the Commerce Clause and taxing under the Taxing Power Clause of Article 1. They also said that that to read regulate as including tax would lead to nonsensical results. For example, the idea that the SEC, because it can, quote, regulate, can also impose taxes on securities transactions, while no one really thinks the SEC can impose taxes on securities transactions. So that was one idea, the idea that regulate doesn't include tax. Uh, a second idea was added by the concurrence, which emphasized wanted to kind of get some specific canons of statutory interpretation in there. So, for example, they add the idea of a no superfluous, words canon, and say that the way that the statute explains so carefully what the president can and can't do, when you read that, you can't understand that to include taxation because because we don't, in order to have taxation be included in that list, you would have to reach the conclusion that there were superfluous words in the statute, is what the concurrence says. The DC District Court adds another idea, a nocitur associus idea, and that idea is that there are so many specific references to what the president can do that you would expect taxation also to be included specifically if it meant to say that. The dissent in VOS elections, it was a 7-4 decision, says as the statutory interpretation question, first of all, Yoshida 2, the case I mentioned, and secondly, it says that regulate importation under IEEPA plainly includes the ability to completely ban all exports through an embargo, and that taxation should be considered to be a lesser included power within that. So there's some of the statutory interpretation, what I would view as like pure statutory interpretation, or not pure. Pure is the wrong word. Like ordinary statutory interpretations without any MQD gloss. Those are some of the arguments that are floating back and forth. We add, professors, we and Ring and I add another idea in the paper that we write, but those are some of the ideas that are out there so far.
And the Federal Circuit decision, I just wanted to pause and observe 7-4, and so much of what we read in the newspapers today, that is, there's a partisan dimension either to the decision or the reporting about the decision, however you want to characterize it. Yet here, it wasn't a matter of, oh, if I can tell you which president appointed which judge, then I can tell you how that judge voted. I thought that was very interesting. And any thought you have on as to why this isn't, obviously or clearly partisan in the way that I've just used that term?
Well, one thing that I think is really interesting is that in the VOS elections case, the group that's organizing the plaintiffs is the Liberty Justice Center, and Professor Ilya Soman of George Mason has been very instrumental in this, as they were instrumental in another case challenging tariffs in 2020, a case that they lost, actually, American Institutes of Steel. And I think that that the idea of libertarianism, limited government, and concern about the excessive power of the administrative state is something that those plaintiffs are pushing against. So I think that that's a fairly, that is a politically conservative idea. It's not the same politically conservative idea as the president's policy has, but that's, I think, part of what's going on. That opposition to some of this is coming from groups that are not left-leaning, but rather might often be said to be right-leaning or libertarian, that sort of thing. As to the kind of the composition of the judges on the court, I think that they have there were both Republican and Democratic appointees, both in the majority and in the dissent in the VOS elections case. And I think that I honestly think that a large part of the docket of the Federal Circuit involves specialized cases like patents and tariffs. And my kind of prior and belief is that the judges, consider themselves to be experts and are sort of trying to figure out what the right answer is here, given the precedent. So I'm prepared to believe that the folks in the dissent just thought, honestly, we give the president the right to ban exports. How can we not give him the right to tax exports? I read it as having relatively little gamesmanship.
Yeah. And I want to sort of bracket this piece because we may return to these types of issues or concerns when we talk about what might happen on November 5th and afterwards. But let's come back to You've been calling it, I think we've been sort of explicating the ordinary statutory
Mhm.
construction
Yep.
issues. Anything more to say on that? Or should we pivot into how the major questions doctrine gloss could be part of how the case is argued, decided on November 5th?
I think there's just one more thing on the ordinary statutory interpretation before we pivot to MQD, which is that ideally a statutory interpretation argument that will be successful for the plaintiffs in these cases will distinguish Yoshida 2. And there's actually also a Supreme Court decision, which is the second most difficult precedent, which is called Algonquin, which is a 1976 decision, a unanimous decision that upheld certain tariffs, but not under IEEPA or a similar statute, under a more specific national security exception statute. Um, and the reason that Shuyi and Diane and I decided to write the paper that we did is that we think that the idea we have for a statutory interpretation argument helps to distinguish those two cases. And the idea we have is that uh, IEEPA is not a, quote, revenue raising statute. It was not intended to raise revenue. And the president is plainly using it to raise revenue. Um, this is different from Yoshida too. President Nixon was not using his 10% baseline tariff to raise revenue. He was using it to move people off the gold standard or off the currency peg. So that we think is a difference, and maybe that will be useful to the court in some way. But the argument that we advance is based on origination clause case law. We know that IEEPA doesn't violate the constitutional origination clause because it originated in the House. We don't have that argument that we can make. But the origination clause case law does differentiate between revenue raising and non-revenue raising statutes. And IEEPA is definitely not a revenue raising statute. If it happens to raise revenue, it's for the specific purpose of responding to a national emergency. And so the idea is the statute's not a revenue raising statute, so the actions that are undertaken under it cannot be revenue raising actions. We'll see if that's at all helpful to the court.
Yes, yes. And really, I want to give you the choice of, right, choose your own podcast adventure because we're on your article, and
Mm-hmm.
I feel like there were the part of the article when you get into this question of statutory interpretation, that's
Mm-hmm.
sort of right where we are.
Mm-hmm.
And I wonder whether do you want to add more to what's in your article with respect to statutory interpretation, or
Yeah.
or right? We were going to go to
Mm-hmm.
major questions doctrine, but I really want to give the up, let you make the choice
Yeah.
because I know exactly sort of where you are in your article from what you shared with us.
Yeah,
So
well, you're so kind to give that opportunity. I mean, maybe one could say a little bit more about the cases in the origination clause case law. Cases like a fee to support the construction of a railroad does not raise revenue. A fee for a crime victims fund does not raise revenue. Um, that kind of thing. A fee to help banks establish a national currency does not raise revenue. Even the Affordable Care Act, DC Circuit, not Supreme Court, said the tax credits and tax provisions in that act do not raise revenue, even though in that case they actually did go into the general treasury fund. So that's like a flavor of what the case law is going for. We'll see if the court likes it. I'm not sure whether they will. They in recent cases they've been a little reluctant to take on the task of distinguishing revenue raising items from non or taxes from fees. So we'll see. But that's the basic idea. And I think that the insight is it'd be good for people to at least know about this because it can make the difference in terms of distinguishing the Yoshida 2 case and the other case. It's called Algonquin. That's a little bit problematic for the plaintiffs in the learning resources litigation. Um, but that I mean I think the MQD is relevant partly because it raises really difficult issues. One reason to lean on the statutory interpretation so much is that if the court does go to the MQD, let alone to the non-delegation doctrine, it gets harder fast. And so I'm happy to talk about that too, if you'd like.
yes, I please because I think that let's do them exactly in the order that that you mentioned them or listed them, which is the MQD, and then of course the last piece or possibility, it seems, uh, the non-delegation doctrine.
Yeah. Well, so the major questions doctrine is a doctrine that has gotten a fair amount of attention in recent terms. It includes an example from the tax context called King v. Burwell, which held that the tax credits under the Affordable Care Act were major questions. It includes West Virginia v. EPA, where the EPA's efforts to regulate climate change related emissions were said to be MQDs. It includes Alabama Association of Retailers, which was a case about eviction moratoria during COVID. And the way that the doctrine works is that, and I'm going to articulate it just as a statutory construction doctrine, if something is a major question, then it must be authorized by a clear statement in the statute. And so you think of it as a clear statement rule. Um, you know, the cases maybe it doesn't need to be so special. Sometimes it actually occurs to me that if the initials were not so cool, like the monogram MQD is just so cool. If it weren't so catchy, then maybe it wouldn't have taken on the way that it has. I mean, in some sense, it makes sense to say, look, if you think the statute is trying to do that big thing, then you should be able to point to the place in the statute where it says it's doing that big thing. It's sort of like maybe it shouldn't have the kind of the marquee lights aspect that it does seem to have. Um, but in this case, the MQD does tend to crystallize something that's really challenging about the case, which is a tension between Article 1 and Article 2. And the reason that it happens this way is that uh, there's an argument that the president has and makes that a clear statement, as under the MQD, should not be required in a statute if the powers that are involved are really Article 2 powers. If they, and here he argues that these powers to impose tariffs are adjacent, at least, to foreign affairs and national security, even though they weren't they weren't enacted under the national security exception, which is section 232. They're enacted under IEEPA. But even so, he says they're adjacent, and they're close enough to Article 2. They are infused with Article 2 powers. In order to run foreign affairs, you need to be able to threaten tariffs and then take them down and negotiate. That's just how it works. And so the MQD should not apply. And so that Article 2 piece, that's the kind of the avenue or the place where Article 2 can come in to try to push back against or shut down the statutory interpretation argument. And because the MQD opens that avenue up to have an Article 2 discussion, it also opens the avenue up to have a responsive discussion about Article 1. In other words, the MQD is the place where there's going to be an Article 1 v. Article 2 showdown in this case, if the court gets to that, or at least that could happen. It sets up the possibility because the president has raised this possibility that the MQD should not be a concern if the powers he exercises are infused with Article 2. So that's what makes the MQD special in this case, I think. That's kind of because the rubber hits the road. After talking for most of this conversation about Article 1, we finally gotten to Article 2, this, the second chunk here, and that's where I think it comes in.
So, and I hope this is helpful. That is, there are three justices who come to mind in thinking about this. And one who I think we've been talking about without naming her is Justice Barrett, because I think the way in which you explained the major questions doctrine as a canon of statutory construction, I feel like that very much channels what she has written about a way of understanding the major questions doctrine. The other two justices who come to mind were on opposite sides of a case that you discuss in the article, the universal service case involving the FCC. And of course, Justice Kavanaugh concurred and Justice Gorsuch dissented in that case. And I wonder whether, this I've sort of moved us ahead, but I feel like this is a way to sort of talk
Hmm.
about
Hmm.
this Article 1 versus Article 2
Hmm.
potential showdown, which is just, you know, what is your sense of how possibly each justice could think about the showdown, or whether there even is a showdown? Is that does that question make sense?
It does make sense. I said at the beginning of the podcast, I think that I have a kind of a beginning part of my career as a tax lawyer, and then moved into teaching property, and I think about administrative law. So I just want to kind of just disclose or acknowledge that I haven't been a court watcher for a long time, honestly. I don't spend a lot of time thinking about the Supreme Court. Um, uh, I mean, I spent enough time that I can, hopefully I'm conversant when I, talk about the major questions doctrine, and I know that people have different views. And I think you're right that the presentation absolutely channels Justice Barrett's way of thinking about it. Um, I think that the thing I can say that might be the most useful is the following, because it does have to do with tax, and I feel confident that I understand this about the Supreme Court and tax. And this case, of course, does involve tax and who has the power to tax. There was a case a couple of terms ago called Moore, and it involved this thing called the realization doctrine in tax. And it was a very audacious claim made that maybe um, the requirement of realization was a constitutional requirement, and that meant that certain international tax provisions were unconstitutional. And the court declined to say that they were unconstitutional. And its decision was extremely narrow and careful. Um, and I think that the reason for that is that they were persuaded that they didn't want to mess with the tax system. Um, and again, is it like I appreciate that this is a view of things that's a little bit nonpartisan and maybe more practical. But I think you read, at least I read more, and I read the justices. I mean, 6-3 decision, but I read the justices saying we can't do that to the tax system. Like, partnership tax law won't work anymore. That sort of thing. So I think that at least some of them will be persuaded, or will at least consider a similar concern in this case, basically as follows. Like, everybody's heard of no taxation without representation. Everybody who would read this decision has heard about that. And the general understanding of that is that Congress passes the tax laws and Congress decides what taxes to impose. And that's not what's happening here. And so, for maybe an adjacent reason, which has to do with the protecting the baseline assumption that Congress does tax, like protecting the baseline assumption that we kind of want partnerships to keep working the way that tax law allows them to work now. That was the Moore thing. Um, I think they're at least going to worry about that. And I think they're not going to want to get too far into the major questions doctrine. And one reason is that on the other side of it, I think that they do want the president to have the ability to do effective foreign policy and national security stuff. And if you go back to, for example, the 1930s, when Franklin Roosevelt Democratic Congress persuaded them to um, pass the Reciprocal Trade Agreements Act, which gave him very sweeping powers to negotiate tariffs compared to what had been done before. I think most people think that was a good thing, that he had that power to reduce tariffs and to get involved with the WTO and GATT and so forth, and lower tariffs and increase free trade. So I don't think they want a decision that takes that away from the president. That makes me think that maybe they feel maybe reluctant to get into the whole Article 1 versus Article 2 mess too much, because there are just risks there. Um, there are just risks there. If they say Article 1 too strongly, then it risks the president's foreign policy discretion. If they say Article 2 too strongly, then that interferes with the way the tax system works.
Okay. And I mean that in a sort of sincere okay. Like
Yeah,
it's helpful to sort of set the baseline here.
right.
I will tell you that I picked those three um, partly because I'm doing a CLE presentation this week on the
Yeah,
universal service case, and so of course
yeah,
Kavanaugh and Gorsuch are very much on my mind. And
right.
I was sort of thinking, oh, well, that is uh, Barrett would seem to, you know, vote to affirm in the sense of, well, if they wanted to say they would have said it's such a big deal, they should have said it specifically in the statute. Justice Gorsuch, in his dissent in that case, really carves out a sort of very emphatic view about Congress and taxation. So it would seem, you never know, it would seem that that would align him with, look, if you're going to do anything with the tax
Mm-hmm.
system, you do it through Congress and you do it
Mm-hmm.
explicitly or expressly.
Mm-hmm.
And it was, I think, in his concurrence, I think it was Justice Kavanaugh, I think it was in the concurrence in this case, who
Mm-hmm.
sort of floated this idea of it wasn't necessary to decide the universal service case, but, well, we don't have to get into the major questions doctrine in certain instances like foreign affairs,
Mm-hmm. He
which
did say
might
that.
lead him to whether or not it's done expressly as a major questions point,
Mm-hmm.
lead him back to, I think the dissenters got it right in the federal circuit about
Mm-hmm.
the president, what authority the president already has.
Yeah.
Um, so we'll
I think you're
see.
right.
Yeah,
Yeah. And
go
you know,
ahead.
Kavanaugh even cites, I think he cites a Tariff case. I believe it's Field v. Clark in his concurrence, um, which certainly raised my eyebrows when I saw that. I thought, well, wow, like now we're saying that Tariff case, which I kind of read more clearly as a delegation case, you know, everything starts in Article 1. Did they transfer it or not? Now he's saying, no, I think it's got some foreign affairs components to it. So I would say that the of the three that you mentioned, uh, Gorsuch was joined by Thomas and Alito in his dissent in FCC Conservatives Research. Maybe it's possible that he would support affirming, but maybe on a slightly different theory than some other justices would. Whereas, as you say, Kavanaugh seems more sensitive to the Article 2 concerns, and maybe for that reason is a little bit more on the side of the dissenters in the VOS selections case, more on the side of the government. Um, Perhaps it's the case that the court would reach a split decision in the sense that they would have different rationales for coming to the conclusions they do. Some adopt the MQD as an essential part of their analysis, perhaps some don't. Um, it's hard to see how you build a majority for the government if Gorsuch, Thomas, and Alito, on the strength of that dissent analysis and FCC for Consumers Research, um, are on the taxpayer side.
Um, yes, those are three votes is a lot of votes in any case
Every
when you're
every
counting to
every
five.
every
Yeah.
presentation, like you say, CLE presentation, every presentation I've been to on this, where I've sort of listened to other people say like I think it's a toss up. I think it's a toss up. Um, I think I read in The Economist that they have an AI predictor of Supreme Court decisions. They ran it 10 times, and 9 times out of 10 it actually went for the government. It's hard to sort of course, look inside the AI black box. I think maybe we may have noted that the former Solicitor General thought that it would be very important that there would be very big refunds in this case, and that would be something that the court would say, "Oh no, we can't have the big refunds, so we have to go for the government." I don't know about that one, but the reasoning I mean, but it does indicate that people on various different sides of the political spectrum, all those I've heard to, have really labeled this a toss-up.
Um, the and we you did mention Justice Gorsuch and the dissent in the universal service case, and I feel like this may be a way we were, sort of circling back, and I just want to sort of complete
Hmm.
the picture, if you will, certainly
Hmm.
the one that I think you sketched in the article, which is the non-delegation doctrine,
Right.
because I have understood him to be, oh, the major questions doctrine he was one of the most aggressive proponents, and I think he really saw it in non-delegation terms. I think that's been sort of muted, at
Hmm.
least by other members of the court, if
Yeah.
not by him.
Hmm.
And yet, uh, it's entirely possible that there may be a non-delegation aspect to the argument and to the ultimate decision making, at least by some, if not, all or five of the justices. So,
Yeah.
just to give you a chance to say a little bit about non-delegation here.
Non-delegation is a doctrine that came out of tariff cases. It came out of Field v. Clark, and the intelligible principle language comes out of a 1928 Supreme Court tariff case called J.W. Hampton. It's very much on brand for a tariff case to raise a non-delegation question. And we can, I think, certainly stipulate that the delegations in the earlier cases were far more specific and detailed than the delegation language in IEEPA. Um, on the other hand, we have not only that Yoshida 2 decision, which said we're construing IEEPA narrowly here to support the Nixon tariffs. It did say if we construed it more broadly, we think there could be a non-delegation question. But there's the Supreme Court case also from the 70s, Algonquin, which upheld the Section 232 national security exception. And that says you can, quote, adjust imports, which is really not that specific. And it was upheld by a unanimous court and decision by Thurgood Marshall. I don't know. It's super on brand for a tariff case to raise non-delegation. An intelligible principle came out of this exact area of law. But given the way that Yoshida 2 and also Algonquin came down, it would be a departure from that precedent for this court to hold there's a non-delegation problem here. Not to mention the fact that there have only been two Supreme Court cases that have ever found a delegation to be void under the intelligible principle doctrine. Those were in the 30s, and um, it's not thought that non-delegation is very robust, except to the extent that it seems to quietly motivate some of these other doctrines, like maybe MQD in some people's view.
Yeah, yeah. Um, well, I think have we covered the waterfront, as the expression goes? Is there anything else that really you'd like to add in terms of either with respect to your article or with respect to what may happen in the case that we haven't already discussed?
Um, I think that the outcome in the case is gonna is really uh, maybe it's going to turn out how risk averse the justices are. If were it me, I just would not want to make it a big decision that says anything like Article 2 wins over Article 1 or Article 1 wins over Article 2. I'd be so tempted to simply say, I'm reading the statute, I'm doing my best to construe the statute. Here are four arguments that say ordinary statutory interpretation. It just doesn't authorize these tariffs. And were I to make that decision, I would have in the back of my mind the likelihood that if that happens and the court agrees with the lower courts and simply holds the tariffs not authorized by IEEPA, the challenge tariffs not authorized by IEEPA, that I would know that the Trump administration would likely go and figure out other ways to impose tariffs. For example, under the national security exception or under an exception for unfair trade practices. Um, and I would know that, and I guess I would have in the back of my mind that it's easier for the administration to justify those as authorized by their respective statutes. So I would say to myself, we'll have another shot at this. And
Uh-huh.
we'll wait to fight that battle on another day.
Yeah, yeah. Well, thank you so much. These are interesting cases. They are complicated cases because there's statutory language, there is lengthy history,
Hmm.
legislative and case law,
Hmm.
and you've done so much to walk us through and explain what's going on. And I can't wait to see how it's all going to turn out. Thank you.
Well, I agree. I too will be watching, and I just want to thank you so much, Roger, and to thank Toro Law Center as well for all your hospitality and inviting me to appear on this podcast. I really appreciate the opportunity, and I most especially want to shout out to my co-authors. Once again, Shu Wei and Diane Ring, this is a collaborative work, and I really appreciate the chance to work with them as well. So thank you so much.
Susie, thank you so much. It's been such a pleasure speaking with you. That's the end of our podcast. Thank you.